Welcome to another episode of Rock the Closing. We are so happy that you're here with us and listening. We have a really important topic today, and that is PCDS. I know you're all wondering. So, Orsolya, what does that stand for?
Yeah, for now, we know what the abbreviation is standing for, but going down the line, everybody is going to just call it PCDS, which means Property Condition Disclosure Statement. So again, PCDS, it's going to be the newest terminology that we're going to be very often using in the legal field. But Dalia, what was there before PCDS and what is it?
Okay, so before the PCDS, we had PCDA, which is a Property Condition Disclosure Act. Okay. This was a credit of $500 due to the buyer in lieu of the statement from the seller, the PCDS. Okay. And the PCDA, this $500 credit, was replaced by the PCDS. So, Orsolya, tell me, when did this change happen? Since when are we required to do this statement rather than the credit?
Right. It's very new. It entered into effect on March 20th, 2024. And this means that any contract signed after March 20th this year will require to have an additional attachment, which is the PCDS, the Property Condition Disclosure Statement. However, if you have signed a contract before March 20th, 2024, and you have not yet closed on the transaction, you can still give the buyer the $500 credit, and you are not required to fill out a PCDS form. Let's go into a bit of detail. What are the basic requirements of the PCDS, or what is it? What is this Property Condition Disclosure Form, Dalia?
Okay, so we have some basic requirements. The good news is that you are not recreating this form as the seller from scratch. Okay, this is a form contract, so it is the same for every purchase. The seller completes the form. And basically what it is a statement of the condition of the property as the seller knows it to be. So the seller completes the form. The form must be delivered to the purchaser no later than when the contract is sent to the purchaser. It's really important that the purchaser knows what's going on with the condition of the property before they even sign the contract. So that is going to be required. It must be attached to the contract of sale at this point, as of March, as Orsolya had mentioned. And the fully executed contract must have signatures of both the buyers and the sellers on that PCDS. Okay. So that's kind of the basics of it. But let's go into detail. Who fills it out? How does it get delivered? What are these conditions, Orsolya?
Okay, so Property Condition Disclosure Act requires that the seller of residential real property makes this disclosure statement and delivers it to the buyer or the buyer's agent prior to signing the binding contract of sale. Residential real property is defined that is a 1 to 4 family dwelling or house. So 1 to 4 family dwelling, which is used and occupied or intended to be used or occupied wholly or partly as the home or residence of one or more persons, but it doesn't refer to unimproved real property, so new development that are going to be constructed. It doesn't refer to condominium units. It doesn't refer to co-op apartments or any property that is belonging to a homeowners associations, which is not owned in a fee simple by the seller. Let me translate it to you because this is from the Property Condition Disclosure Act. Basically, if you own a house that is classified either as a 1-family, 2-family, 3-family, 4-family home, you have to fill out the property disclosure form and provide it to the buyer at the time the binding contract of sale is signed. So only if you own a home that is already constructed and you own the entire home, 1 to 4 family home. The statement, the property condition disclosure, has to be filled out by the seller or the seller's agent, but more about it later. Dalia, what kind of questions are in these statements? So let's take away the mystification and let's talk about it, what this statement is about.
Yes. So the house has got a lot of things going on. So this is going to be a 7-page long document, but most of the questions are yes, no questions. If there's an answer like a yes, you might have to explain what's going on there. Some of them require a little bit of writing, but for the most part, it's really just yes or no. And also you can find this form online if you want to take a look at it as a buyer, as a seller before you go into contract, just to give yourself an idea and maybe try to figure out, do I know the answer to this? So some of these questions will be relating to, like the statement title, the condition of the property. So as a seller, do you know of any smoke damage, any water damage? What is the condition of the pipes? There will be structural questions. How's the roof condition? Is there a sprinkler system? Has there been a radon test? Do you know of any asbestos? Is this house in a flood zone? Is it located in a wetlands area? So a lot of these questions a seller should know the answer to. Some of them you may not know the answer, but definitely have to answer to the best of your ability. So it's a good idea to take a look at that. And if there's some way that you can sort of do a little bit of fact-finding to find out the answer, like, do you have a sprinkler system? You should definitely know that. You don't want to put the wrong answer to simple questions like that, okay? But Orsolya, what is the actual purpose of this statement? Why do we need it?
It's actually to provide information by the seller to the buyer about what he knows, what the seller knows about the condition of the property. It is not a warranty of any kind by the seller. It should not be relied on by the buyer, meaning the buyer should not take this property disclosure form statement as granted and consider it as this is a substitute for any inspection or any testing. So it's just an information provided by the seller to the buyer about the property condition. What happens, however, Dalia, if the seller is not providing accurate information?
Well, that's a big no-no, Orsolya. Sellers need to provide that accurate information. They cannot provide incorrect information. They can't leave out information that they know about. It's going to spell bad news later. So what happens is they will be liable for actual, equitable, or statutory damages for willfully failing to provide the statement to the buyer to the best of their knowledge. An unknowingly false or incomplete statement by the seller on this form may subject the seller to claims by the buyer prior to or after the transfer of title. And that's definitely not something you want. You don't want, as a seller, to close on your house, be done with it, move away, and then next thing you know, you're being called back in for liability on an issue that you knew about and didn't provide information for or provided false information for on a PCDS, okay? It's going to be trouble because you will be held responsible for the information that's provided in this case. So it is important that you provide a complete statement and based on actual knowledge, okay? What else should the seller keep in mind about the PCDS statement, Orsolya?
Right. So first of all, and because as you mentioned that information on the PCDS could lead to liability on behalf of the seller's side, the most important for the seller to keep in mind before filling it out is talk to your attorney. Discuss the statement, discuss the document, discuss the questions with your respective attorney. And your attorney should be guiding you through the whole form, discussing each questions with you, or after you filled it out, you should have a discussion about it for certain with your attorney and follow your attorney's guidance. However, a couple of really general or briefly what the seller should keep in mind would be, what I would suggest is that you always use your actual knowledge. So As a seller, you are not responsible to conduct any inspections. You just fill out the form based on what you are aware of and what is your actual knowledge in terms of the condition of the property. You have to complete the form yourself. I wouldn't give it to your agents, although real estate agents can also help the seller to fill out the statement, but it will be you who lives in the property who knows the best what is the actual condition of the property, and the statement should reflect that. So rather giving it to your real estate agent, make sure that you as the owner are filling it out. There might be some items that are not applicable to your property. For example, you might not have a fuel tank in the underground, which might cause environmental damage. In that case, you will be indicating that it's not applicable. Or certain questions you might not be aware of whether the answer is yes or no. In that case, definitely mark the box unknown, so it's unknown to you. Again, walk through with your respective attorney and discuss the pros and cons of this disclosure statement and follow your attorney's guidance while filling it out. Dalia, when is PCDS provided and who gets it?
Okay, so yeah, the PCDS is going to be provided, like I said earlier, prior to signing. This is as of March 20th, the new rule. Article 14 of the real property law, which is what we in the real estate world requires that the seller of the residential real property to deliver the PCDS to the buyer prior to the buyer signing the contract. So this is a legal requirement. We cannot take it lightly at this point. So that's when it's going to be delivered. However, if the seller acquires any additional knowledge or needs to change something on the form, the accuracy, new information, whatever the case is, then they must deliver a revised or amended PCDS to the buyer as soon as applicable. Okay, so that's important. In that way, you can sort of consider it like a living document. Okay, it's not just as of the date that you send it to the buyer and everyone signs. And because if you do find out something prior to closing after that, you are obligated to reveal that information. Okay, so that's really important. Orsolya, tell me, is the seller required to conduct any inspections to find out, what's going on with their property? If, there are questions on there that they might not know the answers to?
Absolutely not. The seller is under no obligation to do an inspection, to bring in an architect or an engineer or whatnot in order to answer the questions. Whenever the seller doesn't have an answer to the given question, then the seller is going to mark the box, it's unknown to them. There are, however, for example, several questions related to flood zone, and maybe perhaps the seller can review through the FEMA portal, which is the official governmental portal, whether his building is located in the flood zone. But again, it's not required, and the seller, if he never had any issues with flood, he doesn't know how to look up, flood-related questions, the seller can just take and cross out those questions as unknown to him. So there is no requirement regarding the seller to do any inspections because there is an opportunity to mark boxes that are related to unknown. Seller can just opt and choose to cross those boxes out. Okay, we talked about the seller. How about the buyer, Dalia? Does the buyer has any requirements to conduct an inspection?
Actually, they do not. They're not required to conduct an inspection. However, if you are buying a home that is, in the realm of the PCDS, then it is advisable that you conduct all the usual inspections. Get an architect, have a structural engineer look at it, get a termite inspection, do environmental testing, because as we've been stressing, this statement is filled out by the homeowner. They may not know if, there are termites or if the roof is in poor condition. They really may not know. And so for them to put down, no, there's nothing going on here on the statement, you really shouldn't be looking at that as, the be-all, ends-all written in stone. Like, there are definitely no issues with the plumbing, with the electricity. Just because the seller has not experienced any issues or doesn't know of any, you definitely still want to conduct all the usual inspections. As a buyer, you want to look at this statement with a grain of salt, look at what it is that they did say yes to, maybe look into that. But definitely don't take every single statement on there as fact, because it's really just based on the seller's actual knowledge. And we don't always know what their knowledge is based on. Okay. So that's really important to remember as the buyer. So Orsolya, how should a professional go about conducting the delivery and the execution of the PCDS?
Right. We are talking about real estate agents and attorneys. So just really, really general remarks here, because we do not want to overstep. But going forward, I strongly recommend that both agents and attorneys ensure from the very beginning of any transactions that the client has received the PCDS form, has reviewed it, and they discuss the completion of the form with the seller. And also with the buyer, because the buyer also has to understand what the answers are reflecting and whether the buyer can rely on it or not. So review of the PCDS from both sides, sellers and buyers, are very important. In terms of for attorneys, I would definitely pay attention to if there is any conflict between the answers provided by the seller to the PCDS and the contract representation. So whatever the seller is representing in the contract, is that in conflict what he marked and filled out in his PCDS form? For example, in the contract, the seller makes a representation that there was no water damage to the building. And then on the PCDS, he marks that, yes, in the last 1 year, I had a big water damage coming through this and this wall. So attorneys should pay attention to that there is no conflict between the two documents. I would also make sure that the PCDS has to be attached to the fully executed contract, which means that the fully executed contract is received by all parties, including the real estate agents. So agents, be aware that you want to see going forward the PCDS attached to the fully executed contract. We have one such similar document, which is the lead paint disclosure form. And agents are sometimes even reminding attorneys that, hey, you forgot the lead disclosure form. This PCDS form should become just as a similar practice to make sure that it's seen when it's about the sale of a home. Confirm always that both the seller and the buyer have signed the PCDS form. Again, that's something to look out and check for. In my practice, I am always including some disclaimers to protect the seller in my riders. This might be a new practice that attorneys might consider to add to their usual rider language. And then attorneys, again, it's very important to emphasize, walk through your sellers, what they put on the PCDS, explain them the ramification, explain what kind of liability it means, depending what box they are crossing in. And then finally, prior to closing, again, have a conversation with your seller and point out and ask them, was there any material changes compared to what you have submitted at signing? And we know there is quite some time between signing and closing. And point it out to your seller and ask the question to the seller, has there been any material changes since then? Do we need to modify the PCDS form and provide the buyer with a revised version? So again, these are the main advices I would give to real estate professionals. And thank you so much on my behalf. Dalia, over to you.
Yeah, thank you, Orsolya. This is actually a really important and timely topic because it is such a new rule. And a lot of people have been going by the PCDA and just giving the credit. And so not everyone's even seen what this form looks like. So it's definitely timely. It's important to know about and learn about, because this is the new world. We're happy to help you navigate it and tell you a little bit about it, all right? So thank you so much for joining us on this episode of Rock the Closing. We hope to see you next time. Thanks. Thank you for tuning in to Rock the Closing. This podcast is hosted by real estate attorneys who offer valuable insights. Please remember that the content is for educational purposes only and does not constitute legal advice. Always consult a qualified professional before making any decisions. This podcast is copyrighted by Rock the Closing, and any reproduction, syndication, or rebroadcasting of the content requires written permission.